Welcome to this explainer. Okay, let's jump right in because we have a truly fascinating topic to unpack today. We're diving deep into Module 5, Law and Development. We're going to explore how the Indian legal system operates. And spoiler alert, it is not just some static, dusty set of rules. It is actually a highly dynamic engine driving massive social and economic transformation. We'll be looking at how the very concept of development has completely morphed over the years, and how constitutional law is actively deployed to engineer a modern society.
We've got a lot of ground to cover, so here is our roadmap. We'll untangle this by exploring 5 key pillars, starting with conceptual evolution, moving on to rethinking the rule of law, looking at modernization as a constitutional value, diving into agrarian and industrial reforms, and finally, wrapping up with sustainable development.
All right, Section 1, Conceptual Evolution. Let's trace how the very idea of what it means to develop has completely fundamentally evolved over the last century.
When you look at the historical timeline, it really reveals a massive shift in the global mindset. Think about the pre-1945 era. Thinkers like Max Weber equated development purely with economic growth, right? The idea was that formal law was basically just a tool to enforce contracts and protect property for capitalism. Then, fast forward to the 1960s, American academics spearheaded this law and development movement, kind of assuming that if you just transplanted Western legal institutions into the global South, it would automatically trigger modernization. Well, that basically collapsed under its own ethnocentric assumptions. By the 1980s, dependency theory came along with a really sharp critique, arguing that these Western models were actually just neo-colonial tools entrenching inequality. And then, the 1990s hit, and we get an absolute paradigm shift.
This is where the economist Amartya Sen completely revolutionized the space. His capabilities approach shifted the global focus entirely away from just obsessing over GDP growth. Instead, he argued we have to evaluate law based on its capacity to remove unfreedoms and actually enable human flourishing. We're talking about dignity, health, education, political participation. Law suddenly wasn't just about generating wealth anymore, it was about empowering people to live capable, meaningful lives.
So why does this matter? Because this conceptual evolution led directly to the 1986 UN Declaration, which recognized the right to development as an inalienable human right, and uniquely, it belongs to both individuals and collective groups. In India, this was taken a massive step further through constitutional governance. Think about landmark cases like the Olga Tellez case, which famously dealt with the rights of pavement dwellers. There, the Indian Supreme Court powerfully embedded the right to livelihood directly into Article 21, the constitutional right to life. Development literally became a judicially enforceable entitlement.
Okay, moving to Section 2, Rethinking the Role of Law. Now that we know what development actually is, let's examine the primary engine intended to drive it forward.
To really grasp this, we have to contrast 2 opposing views. First, there's A.V. Dicey's classical 19th century view. This is what we call a thin or procedural view. It basically prioritizes formal equality before the law and strict institutional compliance. But critics rightly point out that formal equality often masks deep structural inequalities. On the other side, we have the modern, thick, or substantive rule of law. Thinkers like Ronald Dworkin championed law as integrity. This demands that laws don't just check procedural boxes, but actively deliver justice, protect fundamental human rights, and ensure true democratic accountability.
But here's the paradox, especially in developing nations. During the 1990s, institutions like the World Bank pushed a really heavy agenda of strict property rights and contract enforcement to attract foreign investment. But for countries like India, this one-size-fits-all model has to be incredibly carefully balanced. I mean, strict property rights might attract corporate investment, sure, but if the local marginalized populations can't even access the courts, the law is only working for the wealthy. The rule of law here has to be a continuous, active process of democratizing legal access for everyone, moving way beyond just formal, on-paper compliance.
Let's move into Section 3, Modernization as a Constitutional Value. We're going to see how this builds into the very fabric of the nation and affects everyday life. This brings up a really fascinating intellectual tension, and it's a question we all need to sit with for a second. Can the introduction of a modern legal framework actually dismantle centuries-old social, religious, and feudal structures? Basically, can law lead society rather than just reflect it?
Well, the framers of the Indian Constitution certainly intended it to. They used the Constitution explicitly as an instrument of social engineering. Just look at the Article 51A, Fundamental Duties. They act as these powerful interpretive tools for modernization. They mandate the development of a scientific temper, the promotion of brotherhood, and explicitly demand the renunciation of practices derogatory to women. The law is literally directing society to modernize its epistemological and social values. This is the ultimate clash. Dr. B.R. Ambedkar beautifully articulated the difference between constitutional morality, which demands equality, reason, and fraternity, and popular social morality, which, let's be honest, is often rooted in caste hierarchy and patriarchy. He noted that political democracy without social and economic democracy is just unsustainable. This dialectic is what drove vital, ongoing legal modernizations. We see this trajectory everywhere, from the Hindu code bills of the 1950s granting women inheritance rights, all the way to recent landmark judgments like Navtej Singh Jawhar decriminalizing homosexuality and the Sabarimala case opening temple doors to women. The law is actively replacing traditional social prejudices with constitutional morality.
Section 4. Agrarian and Industrial Reforms. How exactly did the law restructure the wealth of the nation?
Industrially, there was a stark night-and-day transformation. Think back to 1956 and the License Raj. That was a period of heavy state capitalism, mandatory licensing, and intense, suffocating regulation of businesses. But by 1991, India underwent sweeping economic liberalization, shifting heavily to a free enterprise model. Licensing was largely abolished, opening the market to foreign investment. The fundamental right to trade under Article 19(1)(g)(1) was practically expanded, though it obviously remains subject to reasonable state restrictions, shifting the state from being a controller to being a regulator.
Simultaneously, agrarian law saw massive and, honestly, fiercely contested shifts. Post-independence, the state aimed to dismantle feudal structures by abolishing the zamindari landlord system. When those early reforms faced legal hurdles, the First Amendment created the Ninth Schedule, which is basically a constitutional safe box to shield land reforms from judicial review. Then we had the Green Revolution's massive push for industrial agriculture. More recently, attempts to corporatize farming led to the 2020 Farm Laws episode. Now, regardless of where you stand on that, it perfectly illustrated the severe tension between market reforms and the perceived need for social protection, which ultimately led to their repeal. But we also see really progressive structural steps, like the 2013 Land Acquisition Act, which finally mandated social impact assessments and explicit consent clauses for displaced communities.
Now, crucially, all this rapid industrialization led to some catastrophic regulatory failures. The most tragic, of course, was the 1984 Bhopal gas tragedy. In response to that horror, the Supreme Court in the MC Mehta oleum gas leak case took a massive jurisprudential leap. They established the doctrine of absolute liability. This means hazardous industries are held completely liable for environmental and human damages, period. They intentionally stripped away the old loopholes and exceptions found in traditional English strict liability rules.
That exact jurisprudential leap means the right to trade today is inextricably tied to minimum safety standards, worker protection, and a fundamental, non-negotiable duty to the environment. The state absolutely must regulate to ensure that economic growth doesn't come at the cost of human lives.
Which brings us perfectly to Section 5, Sustainable Development. How is the legal system adapting to mitigate the severe ecological costs of all this rapid development?
The concept, which was popularized globally by the UN's Brundtland Commission, is elegantly simple: meet present needs without compromising the ability of future generations to meet theirs. India fully integrated these core principles into its own domestic law, largely through the landmark Vellore Citizens Welfare Forum case in 1996. You have the precautionary principle, which means a lack of full scientific certainty can't be used as an excuse to postpone environmental protection. And you have the polluter pays principle, which is basically exactly what it sounds like, holding corporations directly and financially accountable for cleaning up the ecological damage they cause.
Furthermore, the landmark MC Mia v. Kamalnath judgment entrenched what is called the public trust doctrine. This is huge. It legally recognizes that the state doesn't just own natural resources like rivers, forests, and the air in a way that it can just sell them off to the highest bidder. Rather, it merely holds them in trust for the citizens and for future generations. It's an incredibly powerful legal tool to prevent the commercial alienation of public ecology. Yet, despite these strong legal principles, an intense, ongoing dialectic remains. It's really the ultimate tension, the absolute necessity of infrastructural development, like large hydroelectric dams, versus the human rights of the displaced, often indigenous populations. This was famously litigated in the Narmada Bacho Andolan case, which was this massive legal battle over large-scale dam construction. The law is constantly being asked to mediate between the imperative for national economic growth and the right of marginalized communities to their land and their livelihoods. As we wrap up this explainer, I want to leave you with a final, Critical thought. We've seen how the Indian legal system has evolved from merely protecting property to actively engineering a modern, capable society. But looking ahead, how will the law continue to evolve to balance our relentless economic ambition with the unyielding limits of our ecology and our fundamental human rights? What do you think the next phase of law and development will actually look like? Thank you so much for joining me today, and keep asking these important questions.